in his judgment, or out of his judgment, it appears as if the judge simply wanted to find against us. He's got a personal preference for the extension of agreements. Now, that's not his role. He needs to base his decision on the law. But give us your view on that.
Yeah, that's correct. If you read the judgment, the judge clearly expresses his preference for extension of agreements and the standardization of conditions of employment across a particular sector. And that is not his role. He like you said, he's not there to express his personal opinion. He bases his opinion in the leave of appeal request when you refuse to say, well, that's the scheme of the Act and that's the purpose of the LRA, to promote extension of collective agreements because that promotes sectoral bargaining, collective sectoral bargaining. And it's correct, that is the purpose of the Act. The Act prefers that. However, that does not mean that every agreement must be extended. Each one should be dealt with on its own merits, and there are many sectors where there are no collective agreements that has been extended and they operate perfectly well. What he should have done is he simply should have applied the law. There are certain requirements and safeguards in the LRA that says before you can extend an agreement you have to meet the following requirements, and all he had to do was see if those requirements have been met, and if not, say, well, your interdict has been granted. If they have been met, say, well, interdict dismissed, and not apply his own personal view on whether it should be extended or not, whether it's a good thing or not. He seems to be opposed to the fact that in the past NEASA was able to prevent extension of agreements and to set aside of extensions of agreement. That does not seem to sit well with him, as if we did something wrong by applying the law to protect our members.
And in doing so, supported by many judges in the past. Judges agreed with us by our approach to this. This judge has an issue with us doing this. Now, why is this our approach? How can you apply the same rules for a business operating in an economic hub in Johannesburg versus a guy operating employing 5 employees in the town of Kakamas? All operational needs differs in all respects. The environment differs. The one size fits all, the judge says the one size fits all doesn't work. The judge says by having this approach, NEASA is causing instability in the industry. But who is causing the instability? And what is the effect of the joblessness in the industry? What is the effect on the socioeconomic environment by people not having work? What is the effect on this industry not growing at all? Because it is simply impossible and affordable to employ an employee on the level that's currently required. Just give me an expression of that.
Yeah, just in terms of that, the instability that it allegedly causes if no agreements are extended. The simple fact that since 2011 there has been no extended agreements. They have either been set aside by us or the extension was blocked. And there's been no instability in the sector.
Except for the guys that wanted this agreements extended. Exactly. They would hit hardest by industrial action.
Exactly. The only industrial action you see is during the negotiations by the CIFSAs. That's when you see industrial action in the sector. There weren't any other industrial action. So, I don't.
But did the judge make that decision, express his view on this? Was this even before him? Was that discussed? Where does that opinion come from?
Well, I'm of the view it's his own personal opinion. It stems from his obvious disdain for the fact that we were able to set aside these agreements. And he says that we cause instability by setting aside these agreements, which is simply not correct.